So with that, I am going to say wonderful thank you to Greenberg Traurig for running this program. If you missed the first part of this series, it is available on our YouTube page. I'd be happy to share that link with you. We'll also send it out in the follow-up to this program. But Mian and Liz, thank you so much for putting this together and being such a wonderful supporter of MassMedic. And I'm going to turn things over to you.
Great. Thank you so much, Rachel. Thank you, everyone, for joining us this afternoon for part 2 of our webinar, Legal Toolkit for Early Stage MedTech Companies. Our firm, Greenberg Traurig, has been a longtime supporter of MassMedic for over 10 years. David Dykman, our Boston co-managing shareholder and the co-chair of the firm's life sciences and medical technology practice, serves on the board of directors for MassMedic. We've had co-hosted several events, including several MedTech Partnering Days, which is an annual event that connects some of the New England's most innovative emerging tech companies with strategic partners like J&J, Medtronic, Boston Scientific, Novartis, and many others. Our firm, Greenberg Traurig, has much experience representing companies at all stages of growth. We can help form companies, protect patents and IP, help with employment, real estate, regulatory issues, litigation, mergers and acquisition, as well as IPOs. We have over 2,200 attorneys in 40 offices worldwide, and we serve companies around the world. Our Boston office has about 75 attorneys and a lot of early stage and tech expertise. So let me introduce today's speakers. My colleague Liz Georgiopoulos advises clients of all sizes regarding best practices in information governance and records management, including drafting retention schedules, relevant policies and procedures, and creating and providing related employee training. I specialize in business litigation defense, including breach of contract, breach of fiduciary duties, fraud, misrepresentation, and unfair and deceptive trade practices. With that, I will turn it over to Liz.
Thank you, Mian, and good morning, good afternoon, everyone. Thank you for joining. As Mian mentioned, the first part of my presentation is going to focus on compliance with privacy laws, and then I will touch upon records management, two interrelated areas that are important to consider for all young companies. Jumping to the next slide. Compliance with privacy laws is a tricky area, and that's because there's no general federal data protection legislation. Instead, there are various federal data protection laws that focus on specific areas. HIPAA, for example, is one that readily comes to mind. And then there are various state data protection laws. And I'll focus on California state data protection law today, but as I mentioned, this area is ever evolving. Virginia is now passing a law. So it's something that, always keeps companies on their toes. In the spring of 2018, Europe passed the GDPR, which really brought privacy to the forefront of many companies' privacy programs. And the purpose of the GDPR is to give residents of the European Economic Area more control over their personal data. And it applies to any company that processes personal data of individuals residing in the European Economic Area, regardless of the company's location. So this is very broad, and after this law, many similar laws started being passed in various jurisdictions. Jumping to the next slide, you'll see an image that you're probably wondering what this has to do with privacy compliance. And it really just goes to show that, as I mentioned, this area is always changing. In 2018, companies were focusing on the GDPR, and then the CCPA, which I'll get into on the next slide, caught everyone's attention. Now California is also updating their privacy law and enacting a law called the CPRA. Like I said, Virginia is now passing a privacy law. So there's always something catching our attention. Jumping to the next slide, we'll start focusing on the CCPA to get a feel for what privacy laws typically look like. The CCPA went into effect in January 2020, fairly recently, and it largely mirrors the GDPR, and many privacy laws do actually mirror the GDPR, which is a nice thing because it really helps with compliance and development of privacy programs. The purpose of the GDPR, the CCPA, similar to the GDPR, is to give residents of California more control over their personal data. And this is the case with privacy laws all over the world and the US. The scope of the CCPA is that it covers only for-profit entities that do business in California that meet at least one of 3 threshold criteria. Companies that make $25 million in revenue, have 50,000 California consumers, or more than half of their revenue is generated from personal data sales. On the next slide, we will cover what personal data is under this CCPA. And I'll note that the definition of personal data is very similar throughout privacy laws. It's very broad. In the CCPA specifically, it's information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. This definition is very, very broad. And in addition to sort of obvious personal data items such as name, address, email address, it also includes things like internet protocol addresses, religion, signatures, commercial information, facial recognition, browsing history, and geolocation data. On the next slide, you'll see that the CCPA also provides California residents with 6 individual rights. The first one is that consumers have a right to access the data that you maintain about them as a company. And also consumers have a right to ask you to erase their data. They have a right to know what information's been collected about them and who you've shared that information with. And also a right to opt out of having their information being sold, and a right not to be discriminated against for exercising these individual rights. Jumping to the next slide, we have some tips for CCPA compliance. The first one is prepare a privacy policy, which outlines how your company is complying with privacy laws that apply to you. And this is why you see these coming up in emails and on websites. Also ensure that your company website informs consumers of their rights under the CCPA and or any applicable privacy law, and disclose specific requirements. So these, again, focus on the CCPA. So disclose the categories of personal information collected about consumers and the purpose of their collection, the categories of personal information collected within the past 12 months, and whether the business sells consumers' personal information. A CCPA specific requirement is that companies must actually post a clear and conspicuous link on their websites, indicating that you do not sell personal information. And so that's kind of a CCPA unique requirement that isn't a part of the GDPR, for example. Moving along here, I briefly mentioned that these privacy laws cover personal data. So in addition to consumer data, there are implications for employee data as well. And this would include information related to job applicants, emergency contacts of current or former employees, dependents of current or former employees, etc. Some practical tips for compliance are informing your job applicants of the categories of personal data you collect and the purpose of collecting that information. So you see a reoccurring theme here. It's really transparency. Be transparent about what information you're collecting and why. You can include this type of disclosure on job applications. Also, it's important to ensure adequate security measures are in place to prevent unauthorized disclosure of employee data, and enter into data protection agreements with any third parties with whom the company shares personal information of its employees. So an example of this would be if you engage a payroll vendor to handle any payroll activities. You need to ensure that your vendors are also complying with privacy laws and implementing at least the same security measures you are and protecting data. On the next slide, you'll see that there are some real consequences for not complying with privacy laws. So of course, privacy is incredibly important, and a company wants to demonstrate that it takes privacy considerations seriously. And in the event there is non-compliance, unfortunately, there are real consequences, as I mentioned. Under the CCPA, the California AG is responsible for enforcement and is actually able to impose civil penalties up to $7,500 for each violation. In the event of a data breach, statutory damages can be between $100 and $750 per consumer per incident, or actual damages, whichever is greater. So these numbers can add up real quickly. So it just goes to show that these laws are very important and should be a part of any company's compliancy program to the extent they apply to your consumer base. The next part of my presentation is going to focus on records management. So one requirement under privacy laws is really to minimize the amount of information you maintain, and records manage it and not keeping it longer than you have a business need to do so. And that's where records management comes into play. It's an important area for its own reasons, which I'll get into, but it also helps companies comply with data privacy laws as well. Now, when I say records management, what do I mean? Records management is the systematic control of records throughout their life cycle. So this is creating a record, receiving it, using it, storing it, and then ultimately disposing of it. And when I say record, capital R, on the next slide, you'll see that I'm really talking about any recorded information, regardless of its form, that has value to the company in conducting its business or meeting applicable legal obligations. So this isn't anything that your company creates. So an email to a coworker asking them to go to lunch wouldn't be a record, capital R. It's really something that needs to be kept pursuant to legal obligations and has value. And an important consideration is to remember it's the medium, not the message. Records can exist in a variety of forms, for example, PowerPoint, Word, videos, recordings, paper documents, etc. On the next slide, you'll see that there are two components to a records management program. The first is a records retention policy, which provides the company's guidelines to determine how long it should keep certain information, company records. And then the second is a records retention schedule. And what the records retention schedule does is identify the records that your company maintains and identifies the applicable retention periods for that information. So it would include retention periods pursuant to laws, as well as business needs and best practices. On the next slide, we have some tips here for how to ensure you have appropriate records management practices in place. And in order to do so, it's important to ensure that your employees understand what records should be retained and how to comply with federal and state laws and regulations, as well as the company's business needs and contractual obligations. It's also important that employees understand the length of retention and understanding that it's okay to delete records once their appropriate retention period has been met. Means of storage are important in considering how to organize records for efficient retrieval, and recognizing when and how records should be preserved. So an important consideration here is in the event of litigation, records management programs need to be suspended. And I'll get into that in a couple of slides. Lastly, it's important to also help employees understand when and how records should be properly disposed. To the extent there is personal data contained, it's important to shred that information and dispose of it in a secure manner, is an example of the last consideration. On the next slide, we have some special considerations for email retention. And email is an area that always causes a bit of concern when people associate retention periods in email, just because we use email so much in our day-to-day. But it's important to remember that not every email sent or received is a record with a capital R. And as I mentioned earlier, many emails are transitory. You'll say, attach, please find X. That's an example of a transitory email. So it really is best practice to implement an email retention period at the outset of a business. And the reason for doing so is it really minimizes your company's risk in the event of a litigation. There's less risk that sensitive information will be disclosed if, unfortunately, you're subject to a data breach. So so I say that it often causes an uproar because people don't like to think that their emails will get deleted, but it really is best practice, and it's an important consideration to at least consider. It's also important to create a habit of organizing emails in the same way you would organize paper records so that you can efficiently retrieve them as a part of your operations, and not to rely on email as the main source of company data. As I mentioned before, in the event of a data breach, you don't want all your company records in your employees' active inboxes. It's important to consider appropriate repositories outside of the email system and get rid of the rest of your emails that are really unnecessary. Unless there's a legal hold in place, which I mentioned previously. And on the next slide, you'll see a big red stop sign. And this just goes to show that in the event of a litigation, everything I just talked about has to be suspended. Retention schedules need to be suspended because anything potentially relevant to an active litigation will need to be preserved. So any indications that something could have been disposed pursuant to the records retention schedule needs to be on hold. And then moving along to the next slide, some key takeaways to remember for records management are that you don't need to keep every piece of paper your company creates, and it's actually best practice not to do so. And initially, it's a scary thought, but with time, it gets easier after your records retention program is implemented. Putting a retention policy in place at the outset of a company really helps emphasize the importance of records management considerations and promotes organization. And as I mentioned multiple times, reduces risk and cost in the event of litigation. Lastly, documents or data that are subject to a legal hold must be preserved, notwithstanding any records retention policy or email retention period applied to an active inbox. So always remember that red stop sign in the event of a litigation. And with that, I'll turn it over to Mian.
Thank you, Liz. So what I want to talk about is about tips about how to manage risk of litigation, and the two broad categories that these tips fall into really are what practices, internal practices you can implement for your company to prevent disputes from arising, and then what are some ways that you can improve your or lower your risks of external disputes in the event that another party brings something to your attention. So I'll start talking about fiduciary duties. Fiduciary duties are not just applicable to officers and directors of a publicly traded company, which is something that most people are familiar with, but there are also fiduciary duties may also exist for controlling stockholders, certain key employees, and as well as agents of a corporation. And what fiduciary duties are, their primary two duties, duty of loyalty and duty of care. The duty of loyalty speaks to the concept that as a fiduciary person, you must act in the best interest of the company. And the duty of loyalty is implicated a lot of times in disputes when there are a conflict of interest transactions, where the person with the fiduciary duties has an opportunity to benefit him or herself at the expense of those who he or she owes the fiduciary duties to. And a subpart of the duty of loyalty is a duty of good faith, which is the idea that the person with the fiduciary duty has failed to take action in good faith to prevent a corporate harm. The next duty of fiduciary duty is the duty of care. The idea is that you must carry out your responsibilities with care and prudence. And the issue that is implicated in duty of care cases have to do a lot of times with the amount of time or attention fiduciaries paid to make decisions that appear risky or reckless in hindsight. The other thing I want to have addressed, just to keep in mind, is fiduciary duties are generally owed to, in a public corporation, your shareholders. But there are one instance where fiduciary duties may be owed to creditors, and those happen especially when a company is facing liquidity constraints. So when an entity is solvent, fiduciary duties, like I said, are owed to shareholders. But when an entity is insolvent, those duties are owed to the corporation's residual claimants, which means that body of claimants, including creditors. And then, therefore, if a company is insolvent, decisions have to be made in the best interest of the corporation and its creditors, as opposed to only the shareholders. And you also want to be mindful of contractual rights and obligations when you're facing liquidity constraints. So for example, a financing agreement may have financial covenants that a company is required to meet. And if a breach occurs of a financial covenant or is likely to occur, you have to be mindful of your remedies or your ways to attempt to cure the breach. And then, so I mentioned about internal processes and procedures you can put in place to help guide through better decision making. And those best practices include documentation of your decision making processes. For example, what steps did you take to arrive at the ultimate decision? What materials did you consider? What advice, expert advice did you seek or discuss? And a documentation of those steps is helpful. Also, use of special committees. Can you have a group of 1 or 2 or 3 decision makers that are conflict-free, that can devote special attention to certain decisions? You also want to make sure, to the extent possible, that you retain legal and financial advisors and experts and give their input on company decisions. You want to adopt internal compliance procedures that identify and how conflicts can arise and what process will be taken to handle those conflicts. You may want to consider also a mandatory disclosure requirement of any potential self-interest conflict that may arise. And if there is a conflict, perhaps the way to deal with it is a mandatory recusal of those that have a self-interest conflict. And you want to make sure that you're adhering to corporate formalities and decision-making formalities, so to avoid, exceptions. Because once you have an exception, then the question comes, what other circumstances would give rise to another exception and a third exception? So once you have a set of policies and procedures, you want to make sure that you're adhering to those policies and procedures. Consistent and uniform application of the policies and practices that you implemented. And also consider adopting a set of procedures for conducting due diligence. All these are about making sure that when there are possible conflicts that arise, those are disclosed, and if necessary, the person that may have a conflict, whether actual or possible conflict, may have to be recused from the decision-making policy, such that it is not tainted. And then tools that you can use to protect yourself from minimizing the risk of dispute, or at least the cost of potential dispute from arising, is to think about alternative dispute resolution options. So the most common ones are mediation and arbitration. What mediation is a private process where you invite a third party, a mediator, to help the parties discuss and try to resolve the dispute. Mediation is a voluntary process. The pros of mediation is it is private, and it tends to be fairly informal compared to arbitration or actual litigation, and it tends to be a quick process compared to the other two. The possible downside to mediation is perhaps because it is completely voluntary, you have to have both parties in agreement to um, conduct the mediation. Also, if the parties do resolve their dispute in mediation, then a settlement agreement at the end of a mediation it may need to be enforced by a court order, as opposed to, if you were in litigation, you have a judgment, then it is already a court order. The other common alternative is arbitration. Again, arbitration, like mediation, is a private process where the parties agreed either to have one arbitrator or a panel of arbitrators to make a decision after receiving evidence and hearing arguments. So it's a more formal than mediation, where really you have two parties, perhaps they come in and meet with the mediator, and then the mediator essentially does shuttle diplomacy between the two parties. And sometimes people like to hear arguments, but in mediation, but it's not required and sometimes unnecessary. But in arbitration, oftentimes you will have a presentation of evidence and arguments. The arbitrator has the authority to make the decision about the dispute. It is more familiar than a trial, but is less formal. Arbitration could be binding or non-binding, where if it's a binding arbitration, then the final decision made by the arbitrator will be enforceable by court. If it's non-binding, then the arbitrator or panel of arbitrators will provide advisory opinion, and only final if both parties agree to accept the decision. The pros to arbitration is quicker than actual litigation, and it is having a form of having your day in court, because there is going to be presentation of evidence and then hearing of legal arguments. The con to arbitration is there's no formal rules of evidence like you would have in actual litigation when evidence is being presented to a jury and in court to a judge. So depending on the nature of the dispute, arbitration, formal rules of evidence may be helpful to a certain type of dispute, for example, like fraud, as opposed to other types of dispute. For example, like contract, where you're really down to arguing a provision of contract in a document. So oftentimes, when you're contracting about alternative dispute resolutions, you are looking into the future, which I'll talk about, things to consider. So it's hard to know which one is better for you, but there are ways which I'll address later on about thinking about what would be better option should there be a dispute down the road. Like I mentioned, arbitration, mediation, litigation, those provisions are common in contracts. A lot of times, parties will agree in a contract the location of our arbitration or mediation or litigation, as well as the choice of law. the jurisdiction it would apply, or if any disputes arises, then they will also provide a venue for where the arbitration, mediation, or litigation will take place. One tip you want to think about in terms of deciding which one is suited for the type of business relationship is you want to think about the party that you're contracting with. Do you foresee this as a continuing business relationship? For example, are you a supplier in a supply demand relationship where there's going to be constant shipments and multi-year contract relationship, as opposed to a one-time deal? If it was a one-time deal, depending on the stakes in the contract, you may want to think about arbitration as opposed to mediation. But if it's a business relationship, continuing business relationship, perhaps you just want to quickly resolve the issue by a mediator and then move on and continue that business relationship. You also want to think about, will you have benefits from formal protections, such as an enforceable court decision? If that's something that is important to you, then you may want to think about perhaps litigation or arbitration as opposed to mediation. Also, all three options cost time and money, and depending on the type of resolution option, it has an impact on your business and your business relationships. So for mediation, when you are at mediation, what often needs to happen is a representative or someone with settlement authority. Sometimes mediation can go on for days, but it could also happen in a morning or an afternoon. So mediation, compared to arbitration and litigation, generally has a lesser impact on the actual business operation of a company, as well as time and energy of the business folks. Arbitration, because it involves presentation of testimony, it could happen in a day or over a number of days or weeks. Again, it may be necessary for a representative to be there, but oftentimes you will have attorneys representing you, so the impact may not be as much. Litigation, that's of the three, the most formal presentation of testimony in court. It will involve, sometimes, depending on the nature of the case, many days of presentation, witnesses, and then there's going to be witness preparation. So of the three, litigation is most draining in terms of business resources and business attention from the company. So again, those factors, cost and time, also go into deciding which option is best suited. And it's a hard decision to make, because oftentimes it's asking people to look into the future. One other thing I wanted to touch upon is contracts. I think writing contracts and clear contracts is a really important arsenal in preventing disputes from arising. And even if it does arise, because sometimes it's hard to prevent that, is at least you have a clearly written contract. So the top tip for contract writing is you want to review your agreement as a whole. You don't want to read any specific provision in isolation. When you're reviewing your contract, you want to think about how each provision works with other provisions in the contract, and no provision can be interpreted in isolation. Whenever possible, eliminate ambiguities. It's a little obvious to say that, but it's actually hard to do in practice. And the way you want to think about it is there any word, phrase, or term that's ambiguous? And if I understand it, does the other side understand it? Because perhaps ambiguity may arise when the term, phrase, or word is applied in practice. So you want to think about, is it susceptible to multiple interpretations? Another way to avoid ambiguities is you want to be consistent with the usage of defined terms. What I mean by that is those who have read contracts, a lot of times attorneys will have terms defined in the contract by capitalizing that term. And the term sometimes could be a special term, a specialty term, or sometimes it could be a very common term, but is defined by capitalizing that term and has the associated definition throughout the contract. One of the top mistakes I see that causes ambiguities is when a defined term is used multiple times. Sometimes it is capitalized and sometimes it is not. So then the ambiguity begs the question of when it is used in lowercase, does it still mean the same thing? And that question could be material depending on the provision we're arguing over or the dispute is arising from. And it doesn't really take a lot of time to go through and make sure that the terms that you've defined has been consistently used throughout the entirety of the contract. So it's something small that you can do ahead of time, and it could avoid high costs down the road. Continuing on tips of contracting, you want to make sure you use punctuations carefully. And I have an example in a later slide that will demonstrate kind of when ambiguity and punctuation can really throw off a contract and cost money. You also want to be very sensitive to the scope of any provision that's material to your contract. You want to make sure that you are only providing the scope that's necessary to realize the aim of the contract, and not so broad that it may give the contracting party more rights than is necessary. You also want to avoid boilerplate language. And what I mean is boilerplate language sometimes would have, give an example, you may be using Massachusetts as an example, you might be using a contract that says the form of dispute should be in Massachusetts, but perhaps maybe this contract is about a supply contract with your factory in North Carolina, and if there are any disputes that arises from North Carolina, all the witnesses may be located in North Carolina and not in Massachusetts. So it doesn't make sense for the dispute to be litigated in Massachusetts, and you then have to pay for your employees in North Carolina to travel to Massachusetts. So just think through that the provisions in your whichever contract you're negotiating or reviewing makes sense for that purpose. Also, contracts is where it's an opportunity for parties to allocate cost of risks. If outcomes are uncertain, and a lot of times parties go into contracts with a rosy view of the future, but unfortunately, hopefully it will work out, but oftentimes, well, not oftentimes, sometimes it does not work out. So we want to think about if the outcomes are are uncertain, which party is best suited to accept the negative risks? And if which party is willing to accept possible risks. So those are all things that you can consider and ahead of time before you sign on the dotted line. So as I promised, the example of where clarity and punctuation matters is in a case a couple years back, Rogers Communication versus Bell Alliant. And the particular contract provision that was at issue is subject to the termination provision of this agreement. This agreement shall be effective from the date it is made and shall continue in force for a period of 5 years from the day it is made and thereafter for successful 5-year term, unless and until terminated by 1 year prior notice in writing by either party. So this is basically a continuation duration clause that's very common in contracts. And the issue ended up being whether the qualifying clause, which is the unless and until terminated by 1 year prior notice in writing by either party, modified the initial 5-year period, or whether it modified both the initial period, 5-year period, as well as the successive 5-year term. And the cost of the ambiguity was over $500,000. So my solution to this problem is I would break this sentence into separate sentences and make clear whether you wanted to give the other party, whether both parties' intent was to give the right to terminate both for the first 5 years as well as for the second renewal 5-year period, or whether it is just for the first 5-year period. Ultimately, the case ended up being decided by the French version of this English contract. So that is all to say, the point being that, there's no page limit. Nobody wants to read a very long contract. On the other hand, there is really no page limit to or word limit to your contract. So when in doubt, especially over important terms, you want to make sure that anyone can read those terms and understand exactly what the terms mean. Because if it doesn't, then that's where you're going to have hidden possible disputes arising down the road. So with that, I want to turn it over to see if we have any questions and comments.
Well, I think that, Neon, that was great. And that was a great place to kind of pause on, because obviously punctuation not only saves lives, in this case, it costs $500,000, which is a little bit insane. So, absolutely, audience, please chime in the chat with questions or shoot them over, and you can also use the raise your hand function. So, I think just to kind of boil down on that last point you made, Neon, clarity. What is the best way to go about getting that clarity? You said breaking it down into, obviously no one wants to read a 300-page contract, but there's a reason that you A, hire legal representation to write this kind of stuff, and B, spell it out very clearly. Any other tips for how to avoid confusion?
I think so, defining terms help. Consistently using defined terms help. I don't want to suggest, consult grammar books, because that's not how business is done. But I think the litmus test may be if you are negotiating a contract or reviewing a contract, and if you don't understand, if you have to read a statement for a second time or a third time, that probably is an indication that there's something unclear about it. And you can always grab someone who has not been steeped into that particular contract you're reviewing, ask for his or her take on what the term means, and or what the statement means. And if that is not something that you thought it meant, then you just saved yourself, a potential trap for dispute.
Yeah, absolutely. Liz, I wanted to kind of go back and ask a question. You talked a lot in the beginning about obviously data privacy and new regulations and understanding what that means, right? Europe has different laws, California's passed different restrictions. Where do you see that kind of trending? Are different states going to start potentially regulating per state? Do you think that's something that the federal level will get involved in? Any take on that?
Yeah, that's a great question. And the theme we're seeing is that states, ever since the CCPA was passed in California, we're seeing many states pass similar laws. So I mentioned Virginia. So Virginia recently passed its own privacy law. That's going to go into effect in 2023. Nevada also had done so previously. So I think what we're seeing is that states are beginning to take data privacy very seriously. CCPA and GDPR really paved the way, and now we're seeing laws pop up, as I said, throughout the country. From a federal perspective, I think that's to be seen. Certainly that would help facilitate implementation because, now companies are finding themselves needing to comply with a patchwork of different laws. Yeah. But nothing in the near future. I anticipate in the near future what we'll see is more of these state-specific laws popping up. I'll note too, we're seeing similar laws pop up globally. Brazil has recently passed a similar law to the GDPR. South Africa, various Asian countries, Singapore has a similar law. So unfortunately, the continuation of this patchwork compliance program, I think, is going to continue. But who knows down the road if maybe at some point at the federal level in the US we'll have some more clarity.
Yeah, it's a great overview. I think, what we hear from a lot of companies, both startups and large medical device companies, right, as they look at their pathway for market adoption, market entry, what used to be more attractive in Europe and in OUS atmospheres is becoming slightly less attractive. And I know this is one issue that they're absolutely facing, especially when it comes to digital health products or anything that's really just grabbing a lot of information and then storing it. So I think it's really going to impact, the trajectory of people's market rollout plans. Do you have any companies that kind of come to you all for that kind of guidance as well?
Yes, absolutely. And one thing we help with is assisting with navigating how to comply with so many different laws as a company's expanding, right? And deciding whether it wants to go into a new market. And so a lot of times what I like to recommend is, rather than having different documentation specific to one law, we work together to try to come up with a privacy policy that meets all of the applicable markets that a company may have entered. And in some cases, some requirements may be more stringent and, decisions will need to be made as to whether we want a country-specific addendum or just apply the more stringent requirement overall. So that's certainly something we help with all the time. It's a very common question, and that's where I think we can make a company's life a lot easier as they're expanding, because it can be tricky, but there are ways to facilitate implementation. Because like I said, a lot of these laws have a lot of overlap. And so it can seem daunting, but there are ways to implement a streamlined privacy program that can, meet the applicable market requirements.
That's okay. Great. Understand. That sounds fantastic. And it's probably a really great resource for a lot of the folks on the call and our members as well. I think the other kind of maybe silly question I have, and you can tell me if it's silly, if you're a small company, it's always better for your counsel to draft contracts and agreements, or you let someone else's counsel do it and then your counsel reviews. Is there a standard? What's in your best interest?
So Liz may have her thoughts, and so I think that I don't think it matters who starts. I think it does matter that when it comes to the company's own counsel's lap, that they really have an understanding, a good handle on what the business objective is, what the purpose of the contract is supposed to be, and what the client is willing to give, and what it's absolutely a no. So those are various aspects that that the council needs to think about. Although, on the flip side of that is the thought that the social economic thought that as the drafter of the contract, because you're the original author, you are now wedded to certain provisions, and if you're bargaining from that position, you might have to spend more energy convincing them to move back away from that position. So I guess depending on whether you're in the camp that believes that concept or not, then it really, the important thing is you want to make sure you understand your client's objectives, and what are the areas that is available for negotiation, and what are the areas that are not available for negotiation, as well as think through, what these possible provisions may lead to down the road in the worst case scenario, because I remember reading a contract for a startup, and they were going to go into a project together, and the contract, which was drafted by the other side, allowed auditing of my client's books, and that was wholly unnecessary when and the audit right was for multiple years after the end of the contract. And I told her that you're basically, and she was like, oh, I thought that was it was just allowing them the key to your house. You don't give strangers the key to your house and then let them in and check your cupboards. The same thing with contracting. So I don't know if, Liz, you have different thoughts or.
No, I agree. I think you summarized the considerations very well.
Well, awesome. It looks like we probably don't have any other questions from the audience. So just want to say thank you again, Liz, Mian. That was a fantastic presentation. I know I learned a lot, and thank you to everyone for joining us. If you have questions, absolutely reach out to Liz, Mian. And, Greenberg Traurig is a fantastic resource and someone that we're so thrilled to have as a vital member of our community. So don't hesitate to reach out, and thank you both.
Thank you.
Thank you.
Have a great rest of your day, everyone.